Okay. I see we have a few people already here and it is past. So maybe we'll give a few more minutes so that everybody can just join. Then we'll start. Okay, sorry, I think let us start. Maybe if I can ask for a volunteer. When I have the presentation in front of me, I cannot see any questions when posted in the chat room. So if I can have a volunteer, maybe that will alert me and just tell me what the question is that somebody has posted. I don't know if I have a volunteer. Okay. So you'll have to bear with me so that I can just then see your questions at the end, and we will then deal with them at the end. So as I said before, we have there is rules that was drafted by the rules board, on which they are asking or they're suggesting that there is rules for the children's court alone. The reason being is that there's a lot of confusion amongst practitioners as to if you want to bring an application to the children's court, which rules do you follow, what form do you use a notice of motion, do you use a form 2? So they thought that it might be best if they do rules that is applicable just for the children's court. The rules have not come into effect yet. As far as I understand from what I've followed up, all the consultation processes have been finalized. So they've received all the inputs from everyone which they wanted. and then they are ready to publish, but it seems that date is not known yet, but they have finalized it. So you'll see, so although I still call it proposed rules, because there might have been changes after the consultation process, which I'm not aware of. But as far as I know, this is the rules that they were thinking of publishing. So if I can have a look at the rules. So there's basically 12 chapters. It consists of 65 rules. Annexure A deals with the forms, and Annexure 2 deals with the tariffs that can be asked by legal practitioners in a children's court matter. You'll see I made a note there that that they still have to be developed, so that those tariffs is not yet finalized. And the forms, you'll see when I upload the PDF document, the rule document, the forms are not yet included, but that will be similarly the forms that's already part of the Children's Act. So your Form 2, which you bring an application with, your Form 9, your Form 4. So those are the forms that they are referring to. Then just a breakdown of the rules. So Chapter 1 is Rule 1 to 2. It deals with the purpose and interpretation of the rules. Chapter 2 is just your general rules, usually with the general processes. 3 is just the clerk of the court. 4, the children's court proceedings. So you'll see in the presentation, I focus very much on that Chapter 4, because I think in terms of what we are busy with, this is what will be most relevant. And then Chapter 5, you'll see also from the presentation, I also focus on that a lot, because that is I think also in practice what you will deal with a lot. So those are parental rights and responsibility agreements and parenting plans. Then Chapter 6 deals with child in need of care and protection matters. Again, I've taken some of the rules there so that we can have a look at that. And then Chapter 7 deals with adoptions, Chapter 8 with inter-country adoptions, Chapter 9 with some general rules again, 10 miscellaneous, and 11 then costs, and then Chapter 12. So if I've highlighted some of the rules, as I said, I will upload the presentation and the rules itself also to the web page, so that you can also have it ready when they do publish the rules. So if we look at some of the definitions, which is usually contained in Chapter 1, again, there's not a lot of definitions, but there is a few definitions, and I've really just looked at those definitions that will deal with that is maybe something different, and that you might just make a note of. Applicant has a similar meaning as it has in general civil litigation. It means that person who approaches the court in terms of Section 15 or 53. And then the comfort person, so this is the person you'll see later on when it comes to child participation, they talk about a comfort person. So the definition of a comfort person means a person who is trusted by a child or has close relationship with the child, is not necessarily a party to the proceedings, but who will provide reassurance and comfort to the child during the proceedings. So I think typically maybe a nanny that the child is comfortable with, a peer, a sibling, an older, a major sibling. So a comfort person, that person that will help the child to deal with whatever proceedings is happening in court. You'll see though that it excludes a professional person. So the idea was really not that we now must bring in therapists and social workers and psychologists. This is not the idea. It's just a comfort person, that person that's going to make it easier for the child. So respondent has, for me, a bit of a wider meaning that I think what we would really maybe have in the ordinary civil litigation means any person against whom relief is sought who may be affected by the assistance or relief sought by the applicant, including an interested party. So again, for me, it went, and that's why I put it there, it goes a bit wider, because usually the respondent will be a person against the first part of the definition, against who you ask relief against. So they've gone a bit further to say, well, it can also be somebody that's just affected by the order. Also including an interested party. So that can all be seen as respondents. So the purpose of the rules is to promote the access to the courts and to ensure that all rights have the right disputes that can be resolved by the application of law by a fair hearing before the court is given effect to give full effect of the objects contained in Section 2 and the principles contained in Section 6 of the Act. And you'll remember in the manual that you work through that Section 6 specifically has those general principles of how all children's court matters must be dealt with. They must have the child's dignity and respect at heart. They must be there to promote the child's rights. So the rules is specifically to give effect to that rules that of the sections of the Act that deals with the principles, and then so to also enhance the standard of the best interest and to ensure that all matters are dealt with expeditiously and are prioritized. I think again this hopefully, because the rules are clear in terms of how do you bring an application, how it must place, when it must be placed, there are really going to be a bit of a bit more direction in some of the matters, because I think a lot of times, because there are no clear rules, you know, some courts sort of don't deal with it. Sorry about the dogs. They haven't learned yet about being quiet. So I think in my experience, a lot of times the courts would, you know, they would say, okay, but like, for example, in this one matter that I'm involved in, the magistrate is just not furthering the matter. So at some stage, I served a formal pre-trial notice and say, well, I want the court now to get this matter trial ready. And the magistrate was like, but you know what? No, he's not going to deal with it in this manner. So hopefully with the rules, there's now better guidelines as to how to deal with the matter, who must do what, when, and what must you do in an application. So there's maybe a bit more directions in the matters. So Chapter 1 is the application of the Act. So the court, family advocate, legal practitioner, social worker, or any other suitable qualified person with a like position, having regard to the child's age, maturity, and stage of development, must give due consideration to the views expressed by the child and ensure the child's rights to participate in an appropriate way. So when you apply the rules, those are the principles also that you must have a look at and apply to that. And it's interesting that they mention all those people that must have regard to the rules and how it works. The interpretation, the rules must be interpreted and to construed as to give effect to the following objectives. Now, these objectives very much linked to the Act and the Act objective. So this is always just a more practical. I always think of rules as the how-to. How do you apply? How do you go about doing something? So this for me is always, so this is the interpretation. How do we interpret rules to make them, what is the objective of the rules? So again, that idea that the child's best interests are paramount. that you get a fair hearing, there's a recognition and enforcement of the Constitution and of the other rights under the Act, to secure simplicity and uniformity in procedures and fairness, and to eliminate unjustifiable expenses and delays. So again, that idea of there's a rule, everybody knows what the rule is, it applies in the Children's Court in Victoria, in Makadu, in Port Nolloth, all the Children's Court have the same uniformity, the same procedure. If in practice it's going to work, I think we all know there's challenges with regards to that. A lot of times the courts will have their own little practice directives that runs parallel to the rules, and you're always never sure about exactly what those practice directives are. But I think at least the rules are a starting point. And another is the rules to provide for the care, the protection, and the physical and mental development and social well-being of the child. So those are how the rules should be interpreted. That would be the objective, and to facilitate expeditious finalization of all matters concerning the child without delay. And I know if I talk to a lot of my colleagues that doesn't always litigate in the Children's Court, there's very much this feeling that the Children's Court matters take long. That there's almost never, you go on and on for months and years and it never comes to finalization. Unfortunately, I think sometimes it's true that you do get children's courts that can not come to a decision and therefore the matters become very old. But hopefully with the rules, there's again guidelines that you can go back to as practitioner to say to the court, no, this is how it's been done or should be done, when now that is not there. There's nothing to fall back on so that you can hold the court accountable. Child participation. So again, keeping in mind that we said the Act gives the principle and now the rules come and say how must the child participation happen in the court. Again, I think this is very good because child participation is a lot of times open for interpretation. One magistrate will interpret it this way and the other one will interpret it that way, and some don't do it at all. If you go and look at the proceedings, then you wonder, where was the child? Did the child ever participate? So then again, the rules now say to the court how, a bit more how to have child participation. The rules still use the word to say where it is found that the child is able and willing to participate. Now, I do agree that again leaves a discretion to the court, but which I think is also necessary. At least, child participation must be realistic in terms of where the child is at and if the child can participate. But the rule says the child must be provided with an equal and inclusive opportunity. Now, for me, equal is a big problem in practice because you find that parents have the same opportunity to participate, and then when they want the child to participate, the child does not have the same opportunity to participate. A lot of times it's very after the fact, let's quickly ask the child, or let's quickly let the child participate. So the child doesn't have an equal opportunity to participate. Inform the child of the child's rights and opportunity to participate in an age-appropriate manner. I think that's self-explanatory. Explain the process and the procedure for the child in a simple language and in terms that the child will understand. To deal with the child in a transparent, honest, and respectful manner. Ensure an informal, child-friendly, enable and safe environment. Again, that links to the Act in any way where it says how the children's court must be run. And then take measures to promote child participation in the proceedings, including the appointment of an intermediary interpreter, as well as allowing a comfort person. So going back to the definition, this is where it comes into, so enduring child participation to help the child with this process, to appoint a comfort person. and allocate sufficient time for the hearing, take into consideration that the child needs to rest. So I think child participation, if you look at this rule, is very much where the child is going to be physically in court during a hearing. Where I think if you appoint a legal representative for the child need not be part of the proceedings in this manner. But I know in some courts, I know I've appeared in the Phalaborwa Children's Court a few years ago, and the presiding officer there wanted the child in court, physically in court. And I know there was I think a 5-year-old boy, and he was running around over the benches, under the benches. So the child was there, but there was no participation. The child was just there. So even though this rule makes provision for the participation, it might not always be practical for the child to be there every time. But it would seem that the idea is that at least the presiding officer must do some kind of, I always want to use the investigation to see if this child wants to participate, and if the answer is yes, then at least give an opportunity for the child to participate, and sort of in a respectful manner, because I've also heard horror stories of a poor child being brought in to a court where there's a whole family, all the family members, and the child is questioned in front of the other parties in a very disrespectful and sort of scary manner. So hopefully, as a practitioner, you can fall back on these rules to say to the court, no. There's a specific rule that says you must be honest and respectful. As much as the adults are entitled to be respected, so much is the child to be respected in the process. So case management, again, this is something that is now spelled out clearly in the rules. I'm sure a lot of you that appear in the children's court on a regular basis would feel in any way that the children's court are busy with case management. That's what they do a lot of times. It's, yes, you go back to give feedback or to get feedback, and the court makes decision, but a lot of times it's a bit of case management. So now the rules make specifically provision for that. So it says the objective of case management through judicial intervention in the interest of justice are to protect and act in the best interest of the child to address the problems which cause delays in the finalization of cases. So the presiding officer must conduct the proceedings and must ensure that all applications and inquiries are dealt with judicially and expeditiously. The question, I suppose, and the rules are silent on that. Well, it says here at the bottom, it says the same presiding officer must, where reasonably possible, deal with all applications and inquiries in respect of the matter dealing with a specific child. Now, I don't know, I know some people might be of the opinion that you cannot be the case manager and the presiding officer. So that as if you're both, then maybe if you're then the presiding officer who hears the matter, you might have some preconceived ideas because you were already the case manager. Because I know a lot of times in the High Court, the case manager is not the person that hears the matter, but sometimes it is the same judge. So again, there's not a uniformity, although the rule says, the rules use the word must, where reasonably possible, deal with all applications. And I think we all are aware that a lot of times in the Children's Court, the Department of Justice believes in a rotation system. So it might be that the presiding officer that was case managing your matter is going to be rotated out of the Children's Court in halfway through the case management. So that, the Department of Justice will also have to then say, well, if they want to insist on the rotation system, how is this going to impact on the rules which now say there must be proper case management, and specifically this rule that says the same presiding officer must. And also here specifically, and I think that we're all very glad about that one, that says any failure by a party to adhere to these principles may be penalized by way of an adverse cost order. So again, I think that's excellent, because a lot of times I think in the children's court, we are of the opinion that people get away with murder and there's nothing you can do. You can't punish them in any way for the delays or being, so this is also, I think, a very good introduction by the rules. So I think before we move on, I would sort of just like to sort of check in with all of you and see if there's any questions maybe up to now, any comments that I've maybe missed. Oh, it's Brigitte, sorry, I didn't see your volunteering, so thank you very much. I'll appreciate that, so you can maybe just alert me. Yes, Evie, I see you have your hand up.
Yes, hi, how are you?
Fine, and you?
Good, thank you. I just wanted to ask, practically speaking, in terms of the principle of involving the child in equal opportunities to participate in the process. From a practical point of view, that does prove to be quite difficult in terms of actually bringing the child to the attorney to consult, taking a mandate from the child, particularly where the parents are involved in a high conflict situation where one parent is accused of alienation, parental alienation, and there is inevitably distrust and suspicion of any practitioner that one parent might approach. How do the rules propose to deal with the practicalities of actually engaging a child so as to allow and afford that child equal opportunity as the rules call for?
No, that unfortunately is a good question. I know in the past what we've done is to ask the court for an order saying that the court orders any parent, social worker, or any interested party to have the child present as and when the legal representative wants that child. So I think the children's court does have the jurisdiction to make that kind of order, because that's in the best interest of the child, and therefore the children's court can make an order to give effect to the best interest of the child. So I think it is, I agree, it is a challenge, because you get the resistance a lot of time because there's immediately a suspicion. Because I know, like you, maybe also sometimes you're appointed by a parent, or a parent approaches you, and then there's immediate suspicion from the other parent, especially in these high conflict matters. But I found that a lot of times if you say to the I know a while ago I had a mother that didn't want to leave me alone with the child. So I said, oh, okay, if that's your attitude, then I will just ask the court for an appropriate order. So take your choice.
Are you suggesting that as a matter of course that the children's court be approached for an order before a mandate is even accepted?
I don't think so. I think if during the course of the matter you see you're going to have problems, I would rather ask the court for an order if there's a matter pending before the court already.
I see. All right. Thank you. Thank you.
Okay. Good. Okay. So as there's no other questions for now, then we can proceed. Sorry. Sorry, I just always. There you go. Okay, good. So the next few slide deals with exactly how do you bring a matter to court. The practical steps of how do you do that. So all applications, except it says there, all applications must be brought in terms of a form and corresponding with Form 2. And I'm sure all of you have tried to sort of bypass that to say, yeah, but the rules of the court says I can do a notice of motion. And I'm sure all of us have then run smack back into the wall of a clerk of the court that says, no, if you don't have a Form 2, we're not going to give you a date and we're not going to entertain your matter. So the rules now specifically says that it must. All applications must be start with a Form 2. Then maybe, subject to the provisions of that first rule, you can do a notice of motion corresponding with Form 3 if the nature of the application does not favor the use of Form 2. So I was thinking maybe, because you'll see the rule does make provision for urgent applications. So I would think that maybe if I have to think of a practical example of this, what it says, you can do a notice of motion because a urgent application doesn't fit into a Form 2. So I think then a notice of motion that corresponds with Form 3 can be used. Again, I know that the magistrate courts are very particular also about those forms, that you must then stick to that form, the Form 3, but at least it'll give you a bit more room than the Form 2, because I think you all know the Form 2 is very strict in terms of this section and that section. And the other day I was told by a clerk of the court that her presiding officer don't want you to fill in that section, you must fill in that section. So I said, okay, if that's going to mean that the clerk of the court is going to accept the Form 2, then I'm more than happy to fill in that section and not the other section, despite the fact that it doesn't make sense, but it doesn't matter. So the Form 3, which is now your notice of motion, it says must be accompanied by an affidavit setting out the nature of the application, the grounds upon which the application is based, and the relief sought, and where available, all documents and reports relevant to the application brought to the court. So it says here, if the applicant is the designated social worker, he or she may attach a report instead of an affidavit. I think also keeping in mind that we must remember the children's court a lot of times is used by people in person that doesn't necessarily have a legal background. I find it helpful that this rule actually tells the person that, okay, tell us why you're here, the nature, tell us the grounds, and what is it that you want. So at least for the people that litigate in person, there's some kind of guideline as what is exactly must I put in my affidavit? What must I say? Why am I bringing this application? So every application, and again, what is nice about this, it gives you a bit of, for the people that litigate in person, it gives you a bit more information. It says every application must be contained a full names and residential, postal or work address of the applicant, a cell phone number or a telephone number, including the facsimile. But this is anyway information a lot of times that is in the Form 2. That's how the Form 2 is structured. An election of the preferred address at which the documents may be served, the names, gender, date of birth, nationality, residential address, name of school or preschool of the child in respect of whom the application relates, if available, and the names, the residential or postal or work address, cell phone number, telephone number of the parent or caregivers of the child, including a facsimile or an email address. So then it also says further what it must be in every application. It says the name and the residential or the postal address, cell phone numbers of any person who may be affected by the order, including a facsimile or an email address, and then a statement, so something else further, if whether family advocate, social worker, psychologist, or other professional person or bodies involved, and also giving the full contact details of that person. So again, a specific, has it been to a social worker, has it been to a family advocate? Any particulars of any pending matter or previous order, any court, either interim or final, have been involved in. Hopefully, one might get a bit more transparency and not somebody that's trying to hide a high court order or high court application or application in another court, one hope. If there's an existing court order, full information relating to the change in the circumstances of the case and grounds upon which a relief is sought to change the existing order are based, and any other relevant factors which might assist the court. Again, I think if I work for legal aid, and a lot of time we tell the people to go to court alone. You know, you go and start the process, there's the children's court, there's a form to go and tell your story. So I think, again, for me, if I think about that, the rules is very clear and very prescriptive as to if a layperson is there and they must start an application, what must go in that application. And it might also be easier then for the court to help the people bringing the application. So then the scenario is, okay, the application has been brought to court, has been given, has gone through the administrative processes. And then the question is, okay, what may the presiding officer do? Make any other order provided for in the Act, provided that where applications made for an ex parte order, the provision of Rule 7 must be complied with. So if you have a Rule 7, it just tells you exactly how the application must look and what must be in the application. So if you look at the Act, that would be your section, let me not lie, your section 45 order. So the court, once they receive the application, can then make any order as authorized by the Act. Let me not, yeah, so section 45 and 46, those be your sections. Order the investigation of the application, grant such order as it deems necessary to safeguard and act in the best interest of the child. So I think here, and then if you look at the next one, it says where it becomes better in terms of prescriptive in terms of time periods. It says the court must allocate a date for the preliminary hearing of the application as provided for in Rule 8.1, which date must be within 20 days from the day the matter was referred to the presiding officer. Why I find it interesting is that I had a matter where the magistrate dealt with an application purely administratively. He never gave us a date. He just sent us emails to say, please make submissions. But where the rule says he must allocate a date for the preliminary hearing of the matter, not for him just asking for submissions. If there's an application, there must be a hearing date within 20 days from the day the matter was received. The court must direct whether the child has to attend the hearing, take into consideration the child's age, health, and personal circumstances. So an ex parte application, again, I think this is very much your urgent applications where you, so if you want to do an ex parte application, the rule specifically says, and this is very much in line with your magistrate court rules, with your high court rules, that says the giving of a notice of court proceedings to the person against whom the order is sought would defeat the purpose of the application. So that must be said in your application. Why are you not giving notice? And why is it urgent that it's in the best interest of the child to dispense with the giving notice? So again, that bit of guidance as when can it be urgent? And if it's urgent, what must you tell the court? I'm not serving it because X, Y, and Z, and because of the child. And it must be in terms of Form 3. So again, the next, it says an order made against the party on an ex parte basis is a temporary of nature and must call upon the other party to appear before court on a specific return date to show cause why. So again, similarly, very much the same as your magistrate court rule, as your high court rule that deals with rule nieces. A copy of the temporary order and the ex parte application must be served on the respondents in accordance with Rule 9. So again, just a bit more explicitly, what can you do? Can you bring an urgent application? Because a lot of times, I think it might have sort of over the years, that question has been answered, but there always have been this thing of, but can you bring an urgent application to court, to a children's court? I know sometimes if I speak to some of my colleagues, They're still of the opinion you can't bring an urgent application to the Children's Court, but now the rule makes specifically provision for that. Again, the court is, the rules does prescribe the way of service of notices and documents. It's also very similar to the rules of the Magistrate Court and the High Court. There's nothing really out of the ordinary against it, or out of, different. It can be served by a sheriff, a clerk, a peace officer, or person authorized by the court. So again, maybe a bit more lenient. So if the court can authorize somebody else, maybe the social worker, to go and serve the order. Submitted to a party by registered post, served or submitted in any manner as described by the court, or even a facsimile or electronic mail. So unless directed against the guardian, every application must be served on the guardian and caregiver of the child. Which I didn't put into a slide, but you'll find in the rules make provision for substituted service and edictal citation if you want to serve papers in a foreign jurisdiction. So once the court has now made the determination, given a date for a plenary hearing, the court must have that hearing for the following reasons: gather information and make orders, to investigate, determine who has to be present, deal with interim applications and orders, and give such orders, instructions, or directions to the clerk, a social worker, or other professional as the court deems necessary, and case manage the application in order that it be finalized speedily. And then the court, and it also says here, which is important, I think, well, it might lead to some unnecessary postponements, but the clerk of the court must give at least 10 days notice to any other party of the hearing of the matter. I know in the magistrate courts and even in the High Court, they can be very strict on these 10 days. So I don't know if it might be used as a loophole by some litigants to say, yeah, but I only had 8 days notice and not 10 days. So one have to see about that one, but at least there is a time limit to it. But again, even at this early stage, the court can then already start case managing the matter to make sure it's finished speedily. So even at the preliminary hearing, the rules say the court must give direction in respect of if there must be legal representation of the applicant, the respondent, and the child. I think it's something that happens in any way. The court a lot of times will explain the rights to the parents, you're entitled to legal representation, and then make a decision if the child must be represented or not. See if there must be an interpreter, see if there must be an intermediary, a comfort person, investigation report by a social worker, submissions of reports, affidavits, and supporting documents. So again, that bit of case management to say, okay, I see what I have. Okay, so you must file your affidavit, then you must file this report, then. So again, a bit of case management, so there's not this just a postponement. Because I think a lot of times in the children's court inquiries, what happened now is there's a lot of discussion, and then there's a postponement, but there's no clear direction as to the time limits and what must happen by when. So giving the court, I think, a bit more power to be a bit more strict in terms of this must happen then, this must happen now. Attendance of any other person, so they can decide who else must join the proceedings, exchange of reports and documents, and consider whether to order a conference, a family group conference, or refer to a lay forum. And then whether there's a question of law or fact that might be dealt with separately. Again, something different that the children's court can now say, okay, we'll see this is purely a legal argument. Let's excuse all the parties, just the legal representatives are present. So again, a bit more, giving them a bit more power to be a bit more directive as to how to deal with the matters. right, so let me again stop here to hear if there's any questions up to this stage.
No questions on the chat yet.
Yeah, okay, thanks. Okay, good. Okay, so let's see. Now the next few chapters are a bit more, as I say, I picked those that I think that you in practice going to deal with more, and also taking into consideration a lot of times the questions I get with regards to parental plans, parental rights, responsibility agreements. I think the one question a lot of people will ask is, what's the difference? Now, I usually differentiate it between in the following manner. I would say a parenting plan is exactly what it says. It's a parenting plan. It's a plan between two parents about how they deal with the child. Where parental rights responsibility agreement is, you will remember in the Act it says that any party or any holder of parental rights responsibilities can give it to somebody else. Now, the Act there is not prescriptive in terms of it must be another parent. No, it says any other person. So I know when I was part of the steering committee that implemented the Children's Act, a big thought behind this parental rights responsibility agreements was grandparents. So if you want to give grandparents rights, or uncles or aunts, or an interested person, so your parental rights responsibility agreement will be more that agreement where a parent or parents will give rights to a grandfather, a grandmother, a aunt, or uncle. So it's an agreement that's wider. There's more parties to this agreement than a parenting plan, which is a plan between two parents. So the rules then basically just deals with how this parental rights responsibility agreement must look and what must sort of be dealt with it and how you can deal with it afterwards. So it says it must be in writing with a form corresponding with Form 11. That form is already in the Act, so this is not a new form, but the rule just refers to that. And it contains particulars of the aspects pertaining to care, contact, and the financial responsibility, incidental matters related to the upbringing of the child that are being conferred by the mother or other person upon a biological father or any other person having an interest in the care, well-being, and development of the child. So you see, I think that's also where the confusion comes in, because a lot of times, because this refers to a biological father. So yes, I know a lot of times some of the presiding officers will say that if you deal with a Section 21 application and the parties to that application settles the matter, they would then say the parties enter into a parental rights responsibility agreement. Because in those instances, in the Section 21, the mother is now saying, okay, I acknowledge you as the biological father and I'm giving you rights. It sounds very proprietary, but I think that's what happens. So a lot of times in the Section 21 applications, you will find that there's a parental rights and responsibility agreement, because the mother is conferring rights. But there's also says, or any other interested party having interest in the care and the well-being and development of a child. So the Form 11 must be attached to the application for the registration of the parental rights responsibility agreement. Again, the registration, if you go back to the Act, it says you can take it to the family advocate, you can take it to court. Just in terms of the family advocate, they are very strict. They want you to, the parental rights responsibility agreement must be mediated. That mediator must attach this necessary certificates and so on. Otherwise, they don't register it. So they're very prescriptive in how and when they register their agreements. So where parental responsibilities and rights are to be exercised in substantially the same manner by the biological father or any other person having an interest with respect to more than one child in the same family, such parental responsibilities and rights agreements must be completed for each child. So it sounds very confusing, but I think if you think about it, a lot of times we have complex family systems where there is more than one child that might have the same mother but might have different fathers. So the idea here is that there must be an agreement for each of the child with the respective interested parent or parties. You can't have one agreement between 4 different persons. You must have an agreement for each child. So deals with the process. You must file it, the registration, file copies of such an agreement with the family advocate or the court. And the family advocate must satisfy himself or herself that a parental responsibilities and rights agreement is in the best interest, and this must be stated in a form corresponding substantially with Form 12. So the Form 12 is something the family advocate will issue to say that they are satisfied that the agreement is in the best interest of the child. It says also, you'll see it follows later also, due consideration must be given to the views and wishes of the child in the development of any parental responsibilities and rights agreement, bearing in mind the child's age, maturity, and stage of development. Bearing in mind the child's age, such child must be informed of the contents of the agreement by the family advocate, the court, the social worker, social service professional, psychologist, or the child's legal representative when made an order of court. Where a child, which the involved child is concluded is not in agreement with the contents of the agreement, that should be recorded on the agreement and the matter be referred for mediation or assistance by a family advocate, a social worker, a social service professional, or other suitably qualified person. So this was never part of the, this is not part of the Act, and this is now being brought in terms of the rules, that what happens if the child is not in agreement with this agreement. And I don't know if it's a curse or a privilege, but I'm currently involved in about 5 matters where I act for teenage girls. I don't know how it turned out, but it's all girls between the age of about 13 and 16 with very clear ideas on who they want to stay with, who they want to see, who they don't want to see. So typically I would think that if I have to look at these 5 girls that I'm representing, if they presented with an agreement that they're not consenting to, the rules now say that must be noted and that must then be dealt with. So the parents can be super happy with their agreement, but the child might not be as happy with the agreement. So you'll see similarly with parenting plans, you'll see at the bottom it says that they have exactly the same provision now. So first of all, the child must be informed and the child's views must be taken into consideration. And if the child doesn't agree with it, it must be dealt with, it must be referred for mediation to a family advocate, a social worker, or any suitably qualified professional. So in going a bit back to say a parenting plan is contemplated in section 30. And that is where parents have a problem with the exercising of their rights. So then they must first try to get to a parenting plan and agree on how they're going to exercise their parental rights responsibility. So the plan must be prepared either with the assistance of a family advocate, a social worker, or a psychologist. And then they must do the necessary mediation, and after the mediation by a social worker or any other suitably qualified person, they must then also fill in the necessary form. So again, this is just a bit of process in terms of who does what. So if the family advocate or one of those people do it, then there must be a form 15 or form 16.
There's a question on the chat.
Okay.
Do you want me to read it, or are you going to read it?
No, sorry. If I click at the wrong place, then
fine.
Yeah.
Do you want me to read it to you?
Yeah, sure. Yeah, please.
Can a parental responsibilities and rights agreement be entered into a mother and a biological father where the mother is currently married and the mother's husband is indicated on the birth certificate as the biological father? DNA testing has, however, proved that the mother's husband is not the biological father. Must the mother's husband be party to the agreement, or can only the mother and biological father enter into the agreement?
Yeah. Look, the mother can share her parental rights and responsibilities with somebody else. The problem is the Children's Act says that only if you are the sole or the sole holder of those rights can you share it without the permission of somebody else. But I would foresee that if let's say the husband doesn't have an objection to that, I might just note that in the agreement to say that he hasn't a problem with that. Because the problem is now, if you look at, strictly speaking, at let's call it the paperwork, for the want of a better word, he is identified as the father. So there'll have to be a bit of a Section 21 acknowledgement that the biological father is acknowledged as the father, and that in terms of that he is then given rights in terms of Section 21. So I think my problem is, I think the mother would have been able to just give him rights, but the problem is because she's identified the husband as the child's father, he has rights because he's married. He's the married father of that child. So if there's an agreement, there will have to be some kind of indication that his rights is by consent, or certain of the rights, because he might still, he still has a role to play in this child's life. Because I'm sure, I don't know, but let's pre-expose that this child is going to still be in that home where the wife and the husband is staying, although they're now saying, okay, we are acknowledging the biological father. So I think that's where the parental rights and responsibility agreement is important, that there's a clear setting out of roles. You're going to do this, I'm this, you're going to do that. So I can't see that you can in any way just ignore the husband altogether, because he's still going to be part of that system. So I don't know if that answers the question.
I think so. There's no more chat. So
okay, thank you for that. So yeah, I wasn't anyway gonna sort of go back. Sorry, maybe I'm going to stop there and say, so if there's any other questions about this in terms of, parenting plans and the registration thereof. Okay. So yeah, I think it will be interesting to see how this objection of the child plays out in practice. Going back to my 5 teenage girls that I'm representing, the one didn't want to go back to her mother, and the judge ordered her to go back to her mother. So, it's interesting to see how the courts might give effect to this objection of the children. I suppose also it would depend on how far the objection of the child goes. So Chapter 6 deals with those applications that will deal with children in need and care of protection. Again, I think there's less sort of uncertainty about these kind of applications, because that's what the Children's Court before the Children's Act was dealing with. So I think that process in practice has crystallized a much more than these other applications which the Children's Court got when the Children's Court were made courts of first instance. But I know from a practical point of view and from the practitioners, there is sometimes a feeling that social workers get away with a lot, and they don't follow processes. The rules have now tried also to make that process a bit more clear and uniform. So the social worker must follow it, everybody must follow it, and then you as a practitioner can at least sort of have your little tick box almost to say, okay, this is what must happen, this is what must happen, and the social worker cannot just in the obscurity do more or less what they do. Not that I say that they do, but I think that's sometimes the feeling that a lot of practitioners have. So it says that any person can bring an application that a child is in need of care and protection, and that an application is made for order to place the child in temporary safe care. And that application must be brought in the form of, again, the Form 2, supported by an affidavit on why the applicant says that the child is in need of care. Although if the application is made by a designated worker, they don't have to do a Form 2. So if the court then, as soon as it reasonably possible, can consider the application, may consider such additional evidence as it deems fit, including oral evidence or evidence by affidavit, which shall then form part of the record of the proceedings. And again, what is important here that the rules then say, the parent, the guardian, the caregiver, or the child even may file opposing affidavits, adduce evidence, call witnesses, question witnesses with the permission of the presiding officer, and address the court. So again, that thing of what can you do if you are presented with an application. What's interesting here, a lot of times the perception is that this kind of applications, if one calls one that, can only be done by a social worker when they remove the child or the police remove the child. But if you look at the rules, it says that any person that is of the opinion that a child is in need of care and protection can bring an application in terms of Form 2 to ask the court for the removal of such a child. So it's just a bit of a clarification. I think in practice it is happened, but I think it's not something that people always consider doing. They're more about the care and the contact kind of applications. And then the court can consider the application that's launched, or oral evidence or evidence by way of affidavit, and then what affidavits can be filed if that application is launched. Again, the ex parte application can be on an urgent basis without the notification of the parent or the caregiver. I say sorry, I see I didn't take my picture to the back, so there's a bit of a blank, but I'll make it right before I put it on the web page. So again, there is that thing of if it's urgent, you can do an ex parte application also for a child in need of care and protection. But again, you must explain to the court, if you go back, why are you not giving notice? What will happen if it's in the best interest of the minor children or minor child? And then the presiding officer, if they receive the application, can then make an order for investigation, make any additional orders provided for in Section 50 of the Act. And then the court can place the child in temporary safe care based on the ex parte application. But again, I think you will agree that it's similar. It's going to be similar to any other urgent application. You'll have to make out a case that if you serve the application, the parents are going to disappear with the child, or they might harm the child. Because I think typically, I'm thinking of an example. A colleague of mine got a call from a school to say that the one day they were they found out that this child was bullying another child. And what the schools do nowadays is they call in the person or the child that bullies and the poor victim, and they have a conversation about this bullying. And the next day, the child that was now accused of that she was the one that was doing the bullying came to school with clear bruises and marks. So clearly the presumption was that that night at home, the parents took it up with the child in more the ways than one. And the school was asking, but what now? What must they do? I mean, they clearly are of the opinion if they send this child back to the parents, there's a possibility of further abuse by the parents. So this is typically an application where they would be, if the school want to bring an application to say, don't place the child, safeguard the child, and then launch an investigation.
Sorry, before you go to the next slide, there's another question.
Okay.
Bruce wants to know, so will Form 2 be in addition to Form 22 of the Act in terms of Section 110 of the Act, or is it a separate matter?
Well, if you read the rule correctly, if I understand it correctly, your Form 2 is always the form which you start an application with. Except if you do the urgent application, then you can do a notice of motion. So, yeah, I just want to see if you say 110. Yeah, that's the reporting of an abused or neglected child. So that would be, you can then bring an application. Let me go back one slide. So you can bring an application in terms of must be in a Form 2. So that, because it seems here, that's all things legal, it seems that there must be a Form 2. But then if you look here, it says that you can also do an ex parte application, which you can then do a Form 3, which is your notice of motion. I think practice, we've all learned that in the children's court to be the safest is you complete the Form 2, and then there on the very last page of the application, you have of the form, you have a little block, and then we've learned you write there, see attached notice of motion. And then in the notice of motion, you would then do your ordinary application, be it an ex parte, urgent, but the Form 2 is always that first document. And I think just to be safe, I will always combine the two, although the rules say you don't have to. I just think the clerks of the court, I don't know if they're going to move past the Form 2, because they've been taught that Form 2 is what you use to bring an application. So Bruce, I don't know if that answers your question. Okay, so if the court was then in this application, the court must review whether it was necessary to remove and place a child in interim safe care before the expiry of the next court date, after the removal of the child. The court must ensure that the child, the parent, the guardian, or the caregiver is appropriately informed of the nature of the proceeding, having regard to the provisions of Rule 3. Where the child was removed by a court order, the court must consider any evidence previously received in terms of the rule. The court may, in addition, consider further affidavits or oral evidence, rely on a written report, and where it appears to be in the best interest of the child, postpone the matter for the shortest period of time to call for further evidence or for the purpose of giving notice to any other person whose attendance at the proceedings is necessary. So I think, again, the rules are just a more practical sort of explanation of what's already in the Act, because this process is already in the Act, but it just it gives a bit more practical of how the process must work. And I think that's why I said at the beginning that this might help this whole process of removal of children to be a bit more transparent, because you can question the process a bit more, because there's rules that says this is how the process must work. And again, if the court have this inquiry, have placed the child in temporary safe care and have considered the evidence, the court can postpone the matter for the shortest period of time. But again, you know, what is the shortest period of time? I mean, we all deal with the realities of courts and court diaries. So a shortest period of time, depending on the court, might be a month or 2 months, which I think sometimes a lot of parents will feel, but sure, you removed my child, but now I have to wait another 2 or 3 months before a decision is made if the removal was regular or irregular. So, I mean, I understand from a lot of times from the parent side, and I think sometimes the clients you represent, is that the postponements for the further evidence or the further affidavits can be a bit problematic. So if you go back to the chapter in the Act that deals with removal of children, you remember that either a social worker or police official may remove the child. Those were the two options. And you remember then if a social worker removes the child, then there's a certain process. And if a police official removes the child, there's a certain process. So this rule just goes a bit further to say, if they place a child in temporary safe care without a court order, there have to be reasonable grounds to believe that the child is in need of care and protection and needs immediate emergency protection, and that the delay in obtaining a court order of the removal will may jeopardize the child's safety and well-being. So if you go to the question of that the child is in need of care and protection, you'll have to go back to the Act. And more specifically, and I don't want to lie to you because I always get the two confused, to say when is the child deemed to be a child in need of care and protection. You have to then go back to the Act to say, well, this is what the grounds are for an indication if a child is in need of care and protection. Those grounds that, for example, the child might run away, the child might be victimized further if the child is not removed. Going back to my example of where I said that where the child that was, the school found the child that clearly was abused by the parents the previous evening, or that was the presumption, that would be if they then would say call the police, and the police officer will remove the child then before not sending the child back home. That would say, well, if you're going to send the child home, there's a possibility that the child's safety and well-being might be jeopardized because of sending the child back. So that would be section 150 of the Act, would give you the grounds of when a child is deemed to be in needing care of protection. So those grounds, one of those grounds. And they must be satisfied that removing the child from the child's home environment is the best way to secure the child's safety. And then the court must, before the expiry of the next court date after removal, review whether it was necessary and then confirm the order. But I think that's what the Act also says that there must be the Form 36, which then must then be confirmed by the court before the expiry of the next court date. They must confirm the order. What I've done here, and you must have a look at the rule when you get the document, is specifically Rule 31 deals with investigates the time periods, what the court must follow in terms of certain processes, so where the child is in temporary safe care or where the child is not in temporary safe care. So you'll see a lot of the time periods there is the 90-day time period. It mustn't be postponed for more than 30 days or mustn't be postponed for more than 90 days. I think in practice that does not always follow because just of the whole thing of court roles. The magistrate will say to you, well, my diary for the next 3 months is full. Yes, or 4 months is full. The 90 days is not realistic. It's not a realistic postponement. But a lot of times, I think the courts keep to that, the 90 days and the 30 days and the 60 days. So when you have the rules, have a look specifically at Rule 31 that deals with those time periods that the court must adhere to. So just, you'll see I've skipped a few chapters now, but a lot of the other chapters that deals with adoptions and foster care placement and inter-country adoptions, I don't think in practice you deal with that so much. So if you do come across it in practice, you know there's a rule and you can just go and have a look at the rule. Specifically, the rule deals with settlement agreements. I think typically that is not something the Children's Court have historically dealt with. It's something that we are more used to in a divorce, in the regional court or in the high court or in a civil action. If there's a settlement agreement, it's made a court order. But the Children's Court not necessarily have those things that presented to them. So the rules just makes a provision for how do you deal with a settlement agreement and how do you make it a court order. So if you bring an application, it still must be served upon the respondent unless it originated from the existing court proceeding. So I think for me, typically, I think here of where the parties maybe have between them settled a care or contact dispute, but they both feel more comfortable if the settlement agreement that they've entered into is made a court order, then they would say, okay, one of us is going to apply to the court to make it an order. So that is the application that will follow to make it a court order, which doesn't follow from an existing court proceedings. So the application must, when it's submitted to the court, contain naturally the settlement agreement, an affidavit by the parties confirming the agreement and the signatures of the agreement, and a statement that there's been compliance with Section 6.5. So 6.5 deals with that the court, if you remember, it deals with that the court was, that the child was informed and about the decision that was made. So there'll have to be a statement in the agreement or a separate statement. I know a lot of people put it in the agreement, but it says here a statement that there has been compliance. So for me, it seems that the rule says there must be something other than the settlement agreement to say that there's been compliance with Section 6.5. And then also if the parties agreed that it must be made a court order, then it must also be stated like that. But I think in practice, these things are usually contained in the agreement. I mean, I know when you draft a settlement agreement, they say whereas the parties agree, whereas this, whereas that. But again, it says here a statement to that effect must be made. So again, it seems that the rule would say that there must be something other than the settlement agreement to say that the agreement is to be made a court order. Again, I think with regards to Chapter 10 that deals with some of the general issues, for me, this past week or the week last week, I can't remember, I had this feeling of a social worker just pulling a social worker on me and saying, no, go to the court and get copies of everything from the court. I'm sure a lot of you have had that reaction from a social worker. Because if you read the Act as it stands now, strictly speaking, that is the way to deal with it. The sort of the rule is that the file and the contents of the file belongs to the court, and the court will give you access or not. So it says the rules now specifically sort of, I think, in my opinion, makes it maybe a bit easier, but I don't know, we'll see in practice. It says that any party to the proceedings may have access to the record of the proceedings during office hours at the court where the matter is dealt with under the supervision of the clerk. Any person other than a party to the proceedings may in writing apply to have access to the recordings, stating the reasons why. So the presiding officer can refuse access or grant access and say how or you can have access. What I was thinking also for me, in terms of if you go back to the case management rule and how the court can now case manage a matter, one would typically then ask the court that says, well, as case manager, as you case managing this matter now, please make a directive or a ruling as to how do we deal with the access to reports, the exchange of the reports, who can get what, somewhere from day one, to say, if in this matter, if a social worker's report is available, she must send it to all parties via email. Or nobody's getting any reports, all the reports will be made or received from the court. So that, for me, typically would be something that you would build into a case management to sort of do away with this. Now you have to send your clerk to the court to go and have a look at the court file while in the clerk's court office, sorry. And in these COVID times, now third wave, second wave, and I'm sure there'll be a fourth wave, then access to courts are limited. So I think this is something that in case management should be dealt with. Something contempt. One of the chapters in the study material deals with contempt. Hopefully now, after ex-President Zuma has been sent to prison for contempt, we might get a more serious approach by the Children's Court to parents and parties not adhering to court orders, because in practice it is still so difficult to bring a contempt, or even to get somebody or to get a court to start with contempt proceedings, never mind sending the matter to a criminal court for sentencing. So hopefully, but the rules again is trying to make that a bit easier. So any person during the sitting of the court, so it also goes a bit further, the rules. You'll see here, it says willfully insults an officer of the court, or willfully hinders or obstructs an officer, can be held in contempt, or willfully interrupts the proceedings or otherwise misbehaves himself or herself in the place where the court is sitting, or does anything calculated improperly to influence the court in any matter being or to be considered by the court, may by order of the court be removed. And that person can then, and the proceedings can then continue in the absence of the person removes. So I don't know if you had maybe for me it was a bit strange, but a colleague, an attorney, the one day tried to make a video of a child testifying in court. Don't know why, but we saw him and we said to him, hey, what are you trying to do? So typically this rule, one might say to him, well, he's the lawyer, but this rule doesn't restrict it. It says any person who does anything to calculately improperly influence or disrupt the court may be asked to leave the court. I was just thinking of that example when I was doing the preparation, and if that is conduct that can be seen, because it's not his place to make a video recording of a child testifying. So proceedings to how do you do it? And again, I think the Act does speak to this, but the rules just takes it a bit further. Any person who deliberately or willfully or mala fide disobeys an order may be held in contempt. Again, the application for committal for contempt must be brought in a form substantially to Form 3. So Form 3 is your notice of motion, accompanied by an affidavit and a certified copy of the court order. So what I like about this is now at least there's some kind of process. Okay, so if you want to bring an application for contempt, you do it by way of a notice, you do it, there's an affidavit, and there's a certified copy of the court order. So at least there's a bit of guidance. And then also it says the applicant must prove beyond a reasonable doubt. So it's a fairly heavy onus, but I think that's also in terms of the case law, that the court has granted an order, which is not that difficult because you have the court order, and that the order has been served upon the respondent. Then there's a burden on the respondent to have evidence that the non-compliance was not willful and not mala fide. So the thing that the applicant must prove is fairly simple. There was an order, and it was the respondent knows about the order. And if the respondent fails to put evidence to the reasonable doubt as to whether it was not willful or mala fide, the contempt will have been established beyond a reasonable doubt. So he must put reasonable grounds as to why, or she, is not always a he, why he's not willful or mala fide. I'm just thinking of a practical example where in one of my cases, the one parent, there's an order to say that that parent mustn't go to the school of the minor child, and the parent has now been to the school twice. And I've brought an application for contempt because the parent terrorizes the child at school. So if we look at this, I've established there's an order. He knows about, or she knows about the order. And then the parent must now come and say, okay, well, why is there reasonable doubt? Can he create or she create a reasonable doubt and that there's not a contempt? And that's, you know, the order says you mustn't go to the school. You go to the school. There's not a lot of grounds there. So it says that if an application is received, the clerk must immediately submit the application and affidavit to the presiding officer. So hopefully, I think it might be a bit easier to, in terms of if the rules come into place, to bring an application for contempt. Okay.
Can I ask a question?
Yeah, sure.
I have a potential client who has a child, and the father is now not collecting the child, and the client is an ICU nurse, and so she's wanting the father to have him as much as possible so that she doesn't expose him. Can one use that to enforce the responsibility, because it is the rights and responsibilities? Can one enforce that to enforce his responsibility to fetch the child?
I'd see why not. I mean, it's a court order.
Yeah. Okay.
It's an interesting. It would be an interesting one to see, but I don't see why not.
Okay. Thank you.
Okay. Any other questions? Okay, just maybe a quick feedback on your assignments. Sorry, I'm busy with them. I hope to have them available for you at the latest by Tuesday, to have the results up on the webpage. As soon as I upload your scores, you are notified it. But I know Grace also usually places an announcement on the forum to say that the scores have been released. What I also will do is on the forum, I'll create a separate forum for the portfolios, and I will sort of just generally give you feedback on what I found that there might have been shortcomings or what you could do better or what was done well. I will also put on the forum. Okay, any questions? Okay, so our next, the next.
So, sorry, could I ask one question if I could?
Yeah,
before
sure.
you leave? It doesn't really relate to the rules as such. It just relates to a general question that I have. Insofar as the Children's Act refers to the child, what provision has been made for the child in general class action terms? So we're looking at like a matter of concern for the child as a class, as opposed to specific individual matters of right and protection of individual childs. How do the rules and how does the Act really account for class actions?
Yeah, I think because the Children's Court is a creature of statute, you might have difficulty starting there. But if you look at the Act in general, and remember, you must always read the Act in conjunction with the Bill of Rights. So let's say, for example, I'm trying to think quickly, for example, children of 12 and older have a right to contraceptives. That section in the Children's Act. So if you are aware of a group of children that are not, or HIV and AIDS medicine, they're also entitled to that in terms of the Act. So, but that would go also hand in hand with their rights in terms of the Bill of Rights. So, yeah, I wonder now, you ask an interesting question. I don't, if you say have a group of children that you are aware, because I know there's in some of the children's homes, I know in Benoni I had a visit, they are struggling with Home Affairs to issue birth certificates and ID documents because a lot of the children in the children homes are unaccompanied minors or children abandoned, but they not, nobody ever registered their birth. So I don't see why you cannot group those children together and approach the relevant children's court to say, in your jurisdiction, you're sitting with these children, they have a right to education, they have a right to access to state resources, but without the identity document, without the birth certificate, they don't have access to the state resources, they don't have access to education. So based on that, you might be able to approach the Children's Court based on the child, on that principle. The problem is just that the Children's Court cannot make rulings as to the validity of a section, the validity of a rule. That's why most of the people go to the Children's Court, to the High Court with those kind of applications to say, yes, the Children's Court, the Children's Act gives the child a right, but that right is not met, and therefore I want you to intervene. So I think in theory the Children's Court can be approached if you have one of those rights of the child linked to a human right, linked to a resource that the state is not providing.
I think possibly specific provision should be made in relation to class rights. I don't think it should be dealt with. I think it's deserving of its own specific mention.
Yeah. If you ask, I'm thinking now, I don't know if you're going to put my finger on it. quickly, but there is a section in the Children's Act that says who can approach the court. And then I wonder. Okay, because if you look at section 15, it says that anyone listed in this section, and then it says that under section 15.2, well, it says here, section 15.2c, it says anyone acting as a member of or in the interest of a group or class of persons, and anyone acting in the public interest. See, this C just does not refer to, because I think your question goes that if there's a group of children, if I'm understanding you correctly.
I think more specifically in terms of the rules, you know, how does one practically implement that sort of action?
Okay.
Yeah, because
that's a good point, you know, so that the rules spell it out. So if you're acting as a group, then your application must consist of X, Y, and Z. No, I hear you. It might, you know, that would be a good thing, yeah.
Okay. All right. Thank you.
Okay. Any other questions? Okay, good. Okay. Then our next webinar is on the 13th of July. I will be looking then at the proposed amendments to the Children's Act. It's quite a lot of amendments. Again, I'm not looking at all the proposed amendments. I'm looking at the amendments that has impact on what we're talking about, more the practical side of things. So that might be a bit, if you want to do your planning, we might go on a bit longer than we're doing tonight. So again, we might have a short break in between and then finish that section. Okay. Okay, so if any now, Brigitte, thank you very much for your assistance. I appreciate it.
It's a pleasure. I also just want to follow up with you with regards to the shadowing, but
yeah, currently we have been locked down.
Yes, well, I was going to say.
Yeah, so I know I haven't forgotten about you. I have sort of touched on with her on it. It's just now, especially with the courts, they are very strict. You are either party or legal representative, and that's it.
Yeah,
and if you're not one of those persons, you are not allowed into the court. So I just wanted to give it until, say, middle July. So I just want to see what the courts do in terms of their restrictions. But I haven't forgotten about you, and I have spoken to her, but I will confirm with you for sure.
I appreciate that, but I also don't really want to go to court during, you know, level 3, either 4, whatever, wave 3.
Yeah, unfortunately, you know, the courts nowadays is, it's really bad. There's lots of COVID cases under the court orderlies, the interpreters, the prosecutors, so they're very reluctant nowadays to let anybody into the court.
Yeah, no, I totally understand. Thank you.
Okay.
Thank you for your time.
Okay, you must have a good evening, everyone. Bye-bye.
Bye. Thank you.